Hello, my name is Rob Sterne, and I want to talk to you about the new book, Patent Office Litigation, that will be published in November of 2012 by Thomson Reuters West. I am the editor-in-chief of this new book, which has 23 chapters and over 1,000 pages on the new contested proceedings for the American Invents Act, which went into effect on September 16, 2012 in the United States. This new set of procedures, these contested proceedings as they are called, are probably the most significant change in U.S. patent law in the last 60 years, and from a practical perspective will have as much impact on patent enforcement as the creation of the United States Court of Appeals for the Federal Circuit did in 1982. The book was spawned by an extensive re-examination practice that I and others here at Sterne Kessler, Goldstein & Fox in Washington, D.C. have pursued over the last 6 to 8 years as re-examinations became a more prominent component of patent enforcement litigation in the United States, in the district courts, and in the United States International Trade Commission. Having been involved in over 200 re-examinations myself, including some of the most significant, such as Eye for Eye, which went to the Supreme Court, and the Unilock case that dealt with damages that went to the Federal Circuit, and having a firm that had done over 500 re-examinations, it was clear to me when the American Invents Act was signed into law by President Obama in September of 2011 that a definitive book needed to be written. So over the course of the last 8 months, with many, many hours involving over 30 authors, we have prepared the first definitive book on this subject, which covers not only the contested proceedings themselves, of which there are several, but the pre-existing proceedings that will continue, as well as patent prosecution options for the patent owner. Moreover, since these proceedings operate in the larger context of patent enforcement in the United States, we had to also address how they relate to and not work with, frankly, the U.S. district courts, the United States International Trade Commission, and actions going on appeal to the United States Court of Appeals for the Federal Circuit. So the book has 23 chapters. It includes an overview chapter, Chapter 1. It also has a chapter of scenarios, because multiple proceedings could easily happen against a single patent involving a lawsuit involving multiple defendants. So it is critical for the reader to appreciate this parallel process, this multiple proceeding possibility. And the scenarios chapters address this very complex area with actual examples, albeit hypotheticals, that deal with the various scenarios that will undoubtedly arise. We believe that this book is a very important book for many, many people. Clearly, patent attorneys who are involved in patent enforcement, as well as in-house counsel, need this book. But it's also needed by law students because the book is being used or will be used in law schools around the country that have the first courses on contested proceedings. It also has great applicability to people involved in patent valuation, monetization, and the sale and buying of patents, since these new proceedings will have a dramatic impact on the valuation of these patents and these assets. It is also extremely important for courts, judges, law clerks, magistrate judges, members of the International Trade Commission, members of the United States Patent and Trademark Office, all the government officials that are going to be responsible for dealing with these new contested proceedings and the parallel proceedings in the district courts and in the ITC. And last but definitely not least is the international context. The international context is very important because we operate in an international marketplace today. Chapter 22 deals with and addresses comparable proceedings in various industrialized countries, such as the European Union, and in particular Germany and the European Patent Office, where there are opposition proceedings which are very similar to the new contested proceedings in the U.S. We also deal with Japan, South Korea, Canada, China, and others as we address this international context. And let me close by saying that this is an ongoing project. The Patent Office finalized its rules on August 14th of 2012. The book covers those finalized rules. But it's an ongoing effort because as this new world unfolds, undoubtedly many changes and additions to what's going on will occur in the next 12 months. And with that in mind, we've already begun work on version 2 of the book, which is expected to publish in June of 2013. I hope you have an opportunity to look at it. I hope you have an opportunity to use it. Please give me any feedback. Thank you very much.